Welcome to our special YouTube video series for businesses dealing with the legal aspects caused by the coronavirus COVID-19 pandemic and its impact upon businesses the world over. My name is Christopher Neufeld of Neufeld Legal, and in this particular video we're going to try to provide you with some general direction but not specifics, because every legal situation is so much dictated by the specifics, as you'll see again in this video, as to what happens to your contractual arrangements, your business arrangements that have been adversely impacted by the coronavirus COVID-19 pandemic and the resulting situation of many businesses out of necessity, practicality, or even by government order being closed on a temporary basis. So, what is the situation that you have? Well, first of all, as it comes to contracts, there's three possible scenarios that you can deal with, the impacts on your business arrangements that I'm seeing. The first is the contractual provision in the contract itself of a force majeure clause. The second is the doctrine of frustration. And the third is the jurisdiction in which you're operating and living, whether or not they have a specific statute, such as a Frustration of Contracts Act, which does exist in many jurisdictions, whether states or provinces, although it's something that's quite infrequent because pandemics that shut down businesses on this scale are infrequent. So what happens when you have a contract that is challenged and cannot be fulfilled? How do you deal with it? Well, if there is an actual written contract, that's the first place you're going to look to. And there, the specific language in the contract is going to be the first determinative in how you attempt to resolve the situation. So the most common provision that you'll be dealing with is known as a force majeure clause. Now, force majeure clauses consider aspects of whether there's a war, there's a national strike, there's an impacting strike, there's a government act, there's an act of God. Let's say a major hurricane or tornado smacks through the entire city or town that you're residing in. Then the force majeure clause comes into effect. Now, naturally, these force majeure clauses were drafted by the party that has the substantive amount of power, meaning oftentimes banks, landlords, lenders, franchisors, those kind of parties. So although the contract, and really those contracts, the other side, the small business owner who's involved, didn't really have much ability to say, I want this substantively changed. So they're pretty much forced to have, at the outset, taken the contract as it was. And this of itself poses issues. Because if you actually read through a lot of these force majeure clauses, they're very one-sided. And they provide carve-outs that are problematic from a legal standpoint. So I'm just taking one from a commercial lease agreement for, I believe it might have been office space. And it talks about how the incident could relieve the parties naturally of their obligations. However, at the very end, it has one very critical line where it says, the preceding sentence does not excuse the tenant from payment of rent or the landlord from payment of amounts that it is required to pay in the amounts and at the times specified in this lease. So as you see, there's relief, but then the relief is pulled back with respect to payment obligations. So all of a sudden you have payment obligations that in this situation could be going on for many months. The payment obligations go on, revenues aren't coming in, so technically the landlord is protected, can claim that you're in breach, and now the parties are going to have to look to something beyond the lease agreement or beyond any contract similar to this, realizing at the same time that the other party that has imposed this contract is going to have this as their backstop. Very critical consideration, and why actually it might be beneficial if you did have a hard contract like this in place with this kind of clause. And this leads us to our two other situations, which are actually probably going to be more productive for yourself, but it's still a challenge because people are going to try to hold on to monies that have been advanced. And the first is the common law principle of frustration. So the common law principle of frustration considers that if the contractual arrangement that was created is made impossible by the circumstances for the parties to perform, the contract comes to an end. So if you don't have these kind of force majeure clauses that alleviate pressures onto the more superior party, it may very well be possible to argue for this common law principle of frustration. Because in this particular situation, it's literally impossible for you to now be operating your business, to be generating revenue, to having people coming to your place of business, because the government actually has closed it down. So the contract can technically be at an end. What the implications are of that is going to be so heavily dictated by what kind of government programs, government write-ups are going to be put in place to relieve people. Building on that, there are, I'm going to call it archaic but rarely used statutes known as the Frustration of Contracts Act, which pretty much codified the aspect of the common law and said that, once again, if the contractual situation is such that it now has become impossible for the contract to be fulfilled, that the contract not only comes to an end, but the party, if it's taken money in, cannot claim to retain that money. Now, once again, each scenario is specific to the own statute and to the own fact pattern, so it's a very generalist approach that we're offering up. Nevertheless, one should consider looking at these statutes and, in consultation with legal counsel if they deem it appropriate, which is always advisable, consider what they need to do, often early on, even in the midst of this situation, to deal with the contractual arrangements such that they are dealing with them and putting themselves in a position to move forward. Whether it's regaining deposits that have been advanced to parties, or dealing with contractual arrangements that are going to be problematic and need to be negotiated now, especially now when there is a time for dealing with the stuff. The last thing you want to really be doing is finding yourself coming into the situation once again. The situation's resolved, everybody's scrounging for money and trying to go through the court system to try to effectuate changes. Because unfortunately, going through the courts especially is going to be even more backlogged, because it will be a situation where we have both the current ongoing court processes that were planned, and oftentimes planned months if not years in advance, so we got a very thick schedule where the judges and the system's already backlogged because of the lack of resources. Plus you've got 4 months of stuff that has to be rescheduled, possibly, maybe more months of that, who knows how many months. On top of a whole new era of cases coming up with respect to businesses that have been adversely impacted by their business being shut down by government order, and having to navigate this challenge of how we're going to deal with stuff. So you're going to want to see, if at all possible, if there is room to negotiate. Because trying to get the court system to rule on it, where we don't know what the situation is going to be like playing Russian roulette. You might find, which is oftentimes the case with commercial matters before the court, in the sense that there is no certainty as what the outcome is until you have properly assessed what the facts are, what the law is, and what the government is going to be dealing with to relieve the stress that this has placed on its citizens and on small businesses who have been adversely impacted by the situation. As such, it's always advisable to consult with knowledgeable legal counsel as to what the specifics of your case are and how best to approach it based on those specifics, and how you might best advantage yourself, your family, and your business as you look to move forward. With that, I would say thank you for watching this video. Hopefully it has provided some insight and direction, but you have to build upon it as always, because this is just a very generalist approach to provide you with some direction as to how you might look to deal with this difficult situation that you are presently faced with. Thank you.